My wife brought a stranger into my grandfather's house and called it hers. I'm Douglas Grant, 49, and I've spent the last 15 years managing vendor contracts for an insurance firm in Hartford. You learn to read people when your job is spotting what they're not telling you. But I never saw this coming. The gravel crunched under my tires as I pulled up to the cabin at Lake Willoughby. October in Vermont, the maples were bleeding red, and the air had that sharp bite that makes you think about winter coming whether you want to or not. There they were, on the porch. Marla, my wife of 14 years, sitting calm as ever in her navy blazer. Next to her, a man I'd never seen before, checking notes over a latte that had no business being at a family cabin. The stranger looked up first. Sleek haircut, expensive watch, the kind of confident smile that cost $300 an hour. "You must be Douglas," he said, standing up like he owned the place. "I'm Bryce, Marla's attorney." Attorney? Not our attorney, hers. I didn't shake his hand, I just looked at Marla. She met my eyes with that same detached expression she'd worn for months, like she was already somewhere else. "Everything here counts as marital property," she said. "No hello, no explanation, just business." I set my keys on the porch rail and listened. She started itemizing. My grandfather's trout rod, the one he'd used every summer for 30 years, the maple wood clock that had belonged to his father before him, the hand-sewn quilt my grandmother made during the winter of '72 when the lake froze so thick you could drive a truck across it. Bryce scribbled notes like he was cataloging inventory. "We'll have the place appraised," he said, casual as ordering lunch. "Market value shouldn't be too difficult to establish." Did they think I'd fight them right here, scream about family legacy and blood and memories? I walked inside and started the coffee. The cabin smelled like cedar and old wood smoke. Every board, every beam. My grandfather had cut them himself from trees that grew on this land. The stone fireplace where we'd roasted marshmallows and told ghost stories. The window seat where I'd read books while rain drummed on the roof. 14 years of marriage, and Marla had never once asked about the stories behind any of it. I brought out 3 mugs, white ceramic, nothing fancy. Poured the coffee slow and steady, the way my grandfather taught me. Hot, black, no sugar. "Thank you," Bryce said, like we were colleagues wrapping up a business meeting. Marla didn't touch hers. They kept talking. Liquidation timelines, asset division, fair market compensation. The words floated around the porch like smoke, and I let them. But something inside me shifted, something final. You know what I realized, sitting there listening to them carve up my family's history? This wasn't divorce. This was extraction. Not just from the marriage, from everything that made me who I was. Bryce pulled out a tablet and started showing Marla comps from other lakefront properties. "Similar square footage sold for $420 last spring," he said. "Yours might go higher with the dock access." "Yours, not ours, not mine." Marla nodded like she was already spending the money. "The cabin needs work anyway," she said. "New roof, updated plumbing. Probably more trouble than it's worth to keep. More trouble than it's worth." I'd heard her use that phrase before. About our marriage, about my job, about the time I spent visiting my father during his final illness 2 years ago. That's when something clicked into place. I excused myself and walked inside, past the kitchen where my grandmother had canned vegetables every August, past the bookshelf where my grandfather kept his journals, straight to the stone fireplace. Behind it, hidden in a space only 3 people had ever known about, was the old family safe. My grandfather had shown it to me when I was 12. "Some things," he'd said, "you keep protected. Not from thieves, from people who don't understand what they're worth." I'd never opened it after he died. Never had a reason to. But standing there, listening to Marla and her lawyer discuss selling off pieces of my childhood, I finally understood what he meant. I heard them still talking on the porch. Bryce was explaining tax implications now, his voice carrying that practiced authority lawyers use when they want you to stop thinking and start signing. "Here's the thing about betrayal. It doesn't announce itself. It doesn't slam doors or raise its voice. It sits on your porch drinking coffee and calls your grandfather's house community property. The safe's combination hadn't changed in 40 years. My grandfather's birthday, reversed. The tumblers clicked into place like they'd been waiting. Inside, exactly where he'd left them, were papers I'd never seen before, and a cassette tape labeled simply, "If They Forget." I heard Marla laugh at something Bryce said, the first genuine emotion I'd heard from her in months. They had no idea what they'd walked into, but they were about to find out. I found out the truth 3 days later, sitting in my Hartford office at 6 a.m. The coffee was still brewing when I dialed Janet Rourke's number. She'd been our senior risk officer before retiring last spring, 23 years of spotting financial irregularities that other people missed. "Douglas?" Her voice was sharp, alert. Janet never needed time to wake up. "Everything okay?" "I need a favor," I said. "Background check. Financial forensics. My wife's consulting business." Silence. Then, "How deep do you want me to dig?" "All the way down." You know what's funny about trust? You don't realize how much you're carrying until someone kicks the foundation out from under you. 2 years ago, when Dad was dying, Marla had brought me papers to sign. Power of attorney documents, thick legal folders with little yellow sticky notes marking the signature lines. "This'll make banking easier," she'd said, sitting beside his hospital bed while machines beeped in the background. "Medical bills, estate planning, one less thing for you to worry about." I'd signed without reading. Dad was fading, and Marla was handling the practical details I couldn't focus on. I trusted her. Janet called back at 2 p.m. Her voice had that careful neutrality she used when delivering bad news to executives. "We need to meet," she said. "Not over the phone." She picked a diner in West Hartford, the kind of place where nobody cares about your conversation because everyone's fighting their own battles. Janet slid a manila folder across the booth. "Your wife's company took out a loan 8 months ago. $215,000. The coffee turned cold in my mouth. "Secured with joint property," she continued, "including something called lakefront recreational real estate in Vermont. My grandfather's cabin. The lien lists your power of attorney as implied authorization for the collateral agreement." I opened the folder. Bank statements, loan documents, property assessments, all bearing signatures I recognized. Marla's flowing script, my own tight handwriting on that POA form. "What happens if the court rules the cabin is marital property?" I asked. Janet's expression didn't change. "You're liable for the loan. Pay it off or lose the cabin." The fluorescent lights hummed overhead. Someone's baby was crying 2 booths over. How had I missed this? 15 years managing contracts, and I'd walked straight into the simplest trap in the book. But here's the thing. I'd been carrying something they didn't know about. That night, I drove back to Vermont. The cabin was dark, empty. Marla had gone back to Hartford after their porch meeting, probably to strategize with Bryce about appraisal schedules and liquidation timelines. I went straight to the fireplace and opened the safe again. The papers were exactly where I'd left them. A thick folder with official seals, the cassette tape, and a sealed envelope I hadn't opened yet. The first document was dated 1998. Notarized deed exclusion filed with the Vermont Agricultural Credit Program. Legal language dense as concrete, but the meaning was crystal clear. This property is legacy protected, prohibited from being used as loan collateral. My grandfather had locked the cabin away from banks, courts, creditors, anyone who might try to turn family history into liquid assets. I picked up the cassette tape. "If They Forget," written in his careful handwriting. My hands were steady as I loaded it into the old boom box he'd kept in the kitchen. The tape hissed to life, and then his voice filled the cabin. Clear, deliberate, unmistakably him. "If you're hearing this, someone tried to take what isn't theirs to take. This place stays in the family. No banks, no courts. The law's on our side, but you'll need to prove it." There was more. Instructions about documentation, contact numbers for lawyers who specialize in agricultural exemptions. But it was the sealed envelope that stopped my heart. Inside was a handwritten note, signed by my father, dated 3 months before he died. Temporary permission granted to Marla Grant for use of Lake Willoughby property as collateral security. Agreement void upon my death unless formally renewed in writing. Below that, in Marla's handwriting, "Will destroy this document as requested. Promise. Miss." She'd promised to destroy it, looked my dying father in the eye, and lied. Then she'd kept the note, used it, waited for him to die so there'd be no one left to contradict her story. The betrayal hit deeper than the divorce, deeper than the financial fraud. This was personal, calculated. She'd been planning this while I was holding Dad's hand in the hospital. I called Janet at 11 p.m. "I need those recordings digitized," I said. "Professional quality, certified transcripts." "Douglas, I've reviewed third-party vendor contracts for a decade. You learn how evidence holds when metadata does the talking." She was quiet for a moment. "What did you find?" "Everything. The verification process took 2 weeks. Voice authentication, timestamp analysis, chain of custody documentation. Janet knew people who knew people. Retired FBI technicians who did private consulting. Digital forensic specialists who worked with law firms. Meanwhile, I reached out to Ellie Morrison, a retired lawyer I'd met through work. Corporate counsel, sharp as a blade, with 40 years of experience reading the fine print other people missed. "Interesting case," he said after reviewing the documents. "Agricultural exemptions aren't my specialty, but I know someone who handles ethics violations." That's how I met Sarah Mills. She was nothing like Bryce. No expensive suits, no practiced smile. Just a quiet woman in her 40s who listened more than she talked and took notes in shorthand. "Your grandfather knew what he was doing," she said, spreading the documents across her conference table. "This exemption is bulletproof, has been for 27 years. What about the permission note?" "Interesting question. Your father granted temporary permission, but he specifically made it conditional on formal renewal. Without that renewal, and given the exemption's legal priority, the note has no weight." She looked up from the papers. "Your wife's loan was secured with property she couldn't legally use as collateral. That's material misrepresentation. What happens now?" Sarah's smile was small, precise. "We file a complaint with the Vermont Agricultural Lending Authority. Then we wait for them to notice what your wife's bank missed." I drove home to Hartford that night thinking about chess. Dad had taught me to play when I was 8, and his first lesson was simple. Always think 3 moves ahead. Marla had been thinking 1 move ahead. Get the cabin, liquidate the assets, split the proceeds. But she'd missed something crucial. The game wasn't over. It was just beginning. I called Marla on a Tuesday morning. Calm, professional, like I was scheduling a vendor review. "We should meet again," I said. "At the cabin, discuss terms." Her voice brightened. She thought I was surrendering. "Of course. Bryce will want to be there. We can finalize the valuation, talk about timeline." "Saturday at 2, I said. "I'll have coffee ready." What she didn't know was that I'd spent the week preparing the battlefield. Sarah Mills had helped me understand the legal architecture. Janet had verified every document. But the execution? That was all mine. I drove up to Vermont Friday night. The October air was sharper now, carrying the promise of winter. The cabin sat dark against the lake, waiting. I had work to do. First, the digital recorder, smaller than a deck of cards, professional grade. Janet had borrowed it from a private investigator she knew, the kind that recorded boardroom conversations for securities fraud cases. I tucked it behind the mantel, invisible unless you knew exactly where to look. Next, the documents. I'd had Sarah's assistant prepare copies of everything. The 1998 deed exclusion, the certified transcripts, the loan papers showing Marla's violation, each one marked with red stamps. Legacy exempt, non-liquidable. I arranged them on the kitchen table like evidence in a trial. The safe I left half open, not obvious but visible if you were paying attention. A glimpse of manila folders and old papers, like treasures waiting to be discovered. Finally, I brewed coffee. The same white ceramic mugs. The same careful ritual my grandfather had taught me. Everything had to feel normal until it wasn't. Saturday at 1:45, I heard their car in the driveway, 2 doors slamming, confident voices discussing strategy. They walked onto the porch like they'd already won. Bryce carried a leather portfolio thick with documents. His smile had that practiced warmth lawyers use when they're about to charge you 6 figures. "Douglas," he said, extending his hand. "Ready to move forward?" Marla followed behind him, checking her phone. Business casual today. Pressed slacks, silk blouse. The outfit she wore to close deals. "Hope you don't mind," Bryce said, settling into the same chair he'd occupied 2 weeks ago. "I brought some preliminary paperwork, streamline the process." I poured coffee. Let them get comfortable. Bryce opened his portfolio and started spreading papers across the porch table. Valuation estimates, liquidation timelines, asset division worksheets. Market analysis shows comparable properties running 420 to 460, he said, pointing to charts with colored highlighting. Given the cabin's condition and dock access, we're looking at the higher end of that range. Marla leaned forward. "I've been thinking about a buyout option," she said. "Instead of selling to strangers, maybe you'd want to keep the place. Pay fair market value for my half." Fair market value for half of something that had never belonged to her. You know what I realized, watching them divide up my family's legacy like a corporate acquisition? They weren't just stealing property. They were erasing history. Every summer I'd spent here with my grandfather, every lesson he taught me about patience, about legacy, about protecting what matters, every story he'd told while we sat by this same lake, watching the sun set behind mountains that had been here long before any of us were born. To them, it was just square footage and lake frontage. I let them talk for 20 minutes. Bryce explaining tax implications, Marla suggesting payment schedules. Their voices carried that casual authority of people who've already decided your fate. Then I stood up. "Before we start splitting things," I said, walking toward the front door, "I want to show you what was never ours to split." I led them inside, past the kitchen with its annotated documents, past the bookshelf where my grandfather's journals still sat undisturbed, straight to the fireplace. The safe door was exactly where I'd left it, half open, inviting questions. "What's that?" Bryce asked, like he'd discovered something significant. I didn't answer, just opened the safe wider and started laying documents on the coffee table. First, the notarized deed exclusion, official seals, legal stamps, 27 years of legal protection. "Vermont Agricultural Credit Program," I said, reading the header, "filed October 15th, 1998. Bryce leaned forward, squinting at the text. His confident expression started to shift. Next, I placed the certified transcript of my grandfather's voice. Professional formatting, timestamps, authentication signatures. "Audio recording, digitally verified," I said. "Would you like to hear it?" I didn't wait for an answer, just pressed play on the portable speaker I'd prepared. My grandfather's voice filled the cabin. "This place stays in the family. No banks, no courts." The silence that followed was perfect. Bryce's hands had stopped moving. Marla's coffee cup sat frozen halfway to her lips. But I wasn't finished. I turned to Marla. My voice was cold, slow, each word measured like contract language. "You're banking on a note my father wrote, the one you said you'd destroy." Her face went white. I slid out the second transcript. My father's certified voice recording. The one where he'd explained the conditional permission and Marla's promise to destroy the document. She kept that paper. She wasn't protecting the family. She was preparing to betray it. Bryce glanced at Marla. His lawyer instincts were screaming now, telling him something had gone very wrong with their case. Marla said nothing. Her mouth opened slightly, but no words came out. The silence did all the damage. This property has been legally protected from creditor claims since 1998, I continued, my voice steady as a contract reading. Your loan was secured with collateral you couldn't legally use. That's called material misrepresentation. Bryce found his voice first. There might be some procedural questions, but the permission note expired when my father died, I said, unless formally renewed in writing, which it wasn't. I laid out the final document, a certified copy of my father's death certificate, with annotations showing the legal termination of all temporary agreements. Bryce stared at the papers like they were a death sentence, which, for his case, they were. The loan you're counting on? I said. It violated federal agricultural lending guidelines. The bank missed it, but the state won't. Marla finally spoke. Her voice was barely a whisper. Douglas, we can work this out. We don't need to. We? I let the word hang in the air. There is no we. There hasn't been for a long time. I started gathering the documents, careful and methodical, like closing a case file. Here's what's going to happen, I said. Sarah Mills has already filed a complaint with the Vermont Agricultural Lending Authority. Your loan will be declared invalid. The lien will be voided. Bryce was reading the deed exclusion now, his face growing paler with each paragraph. And the bank? I continued. They're going to want their money back. Full repayment. Immediately. Marla's hands were shaking. You can't do this. I looked at her. Really looked at her. For the first time in months. I'm not doing anything, I said. I'm just letting the law work the way it was designed to work. I walked to the safe and started putting everything back inside. The documents, the recordings, the evidence of 27 years of legal protection. You came here to take my grandfather's house, I said, closing the safe door. The lock clicked with a sound like finality. But you never bothered to find out if it was yours to take. Bryce was already packing his portfolio. His billable hours had just turned into a liability nightmare. Marla stood in the center of the room, surrounded by the history she'd tried to liquidate. The coffee's getting cold, I said, walking toward the porch. Neither of them followed me. Within 10 minutes, their car was pulling out of the driveway, gravel crunching under retreating tires. I sat on the porch, finishing my coffee in the silence they'd left behind. The lake was still, the mountains hadn't moved. Everything that mattered was exactly where it belonged. Sarah Mills filed the complaint on Monday morning at 9 a.m. sharp. I was sitting in my Hartford office when she called. It's done, she said. Vermont Agricultural Lending Authority has everything: the exemption deed, certified recordings, POA misuse documentation, all linked directly to your wife's loan agreement. The dominoes were falling now. Sarah had explained the process like she was teaching contract law. When property under agricultural exemption gets used as collateral, it triggers automatic review. Federal guidelines, no discretion involved. Within 48 hours, the lending authority's response landed in my email. Official letterhead, case number, findings of material misrepresentation. The cabin's use as loan collateral violated rural lending exemption clauses that had been in place since 1998. The lien was voided immediately. Marla's loan was forced into default, full repayment demanded within 10 business days. $215,000. Due now. I printed the letter and read it 3 times. Each paragraph felt like vindication written in legal language. But the real satisfaction came Thursday afternoon, when Bryce called my office. Douglas, we need to talk. His voice had lost that practiced confidence. There might be room for negotiation here. I don't think so, I said. Look, nobody wants this to get messy. Maybe we can work out some kind of arrangement. I hung up. Friday brought the court hearing, Marla's last chance to salvage something from the wreckage she'd created. The courthouse in Burlington was exactly what you'd expect. Marble floors, high ceilings, the kind of place where justice moves slowly but deliberately. Marla sat at the plaintiff's table with a new lawyer. Bryce was nowhere to be seen. Her attorney was older, more careful, the kind who specialized in damage control rather than aggressive litigation. Sarah and I took our seats at the defendant's table. She'd arranged our evidence in neat folders, everything organized like a corporate presentation. "Remember," she whispered, "let them make their case first, then we show why it doesn't matter." The judge was a woman in her 60s with silver hair and the patient expression of someone who'd heard every excuse in the book. Marla's lawyer stood up first. "Your Honor, this case involves a simple misunderstanding about property rights. My client acted in good faith, based on written permission from the property owner's father." He submitted the handwritten note. The one my father had signed, the one Marla had promised to destroy. This document clearly establishes temporary permission for collateral use. While there may be technical questions about agricultural exemptions, the intent was clear. I watched Marla during his presentation. She sat perfectly still, staring straight ahead. No emotion, no fidgeting, the same controlled expression she'd worn during our divorce discussions. Did she really think this would work? Sarah stood up for our response. No dramatics, no flourishes, just facts. "Your Honor, the plaintiff's argument ignores federal law that's been in place for 27 years. This property was declared exempt from creditor claims in 1998. That exemption supersedes any temporary permissions." She submitted our evidence methodically. The 1998 deed exclusion, the certified voice recordings, the timeline showing my father's death, and the automatic termination of temporary agreements. "More importantly," Sarah continued, "the defendant's father specifically addressed the situation in recorded statements. He understood that keeping the permission note would constitute a betrayal of family trust." She played my father's voice in the courtroom. If she kept that paper, she wasn't protecting the family, she was preparing to betray it. The silence that followed was devastating. Marla's lawyer tried to object. "Voice recordings lack proper chain of custody." "Already authenticated," Sarah said, handing him the certification documents. "Professional voice analysis, timestamp verification, metadata authentication, all performed by certified forensic specialists." The judge reviewed everything for 20 minutes, reading, cross-referencing, checking dates and signatures. Finally, she looked up. "The court finds that the 1998 agricultural exemption takes legal precedence over any subsequent permission agreements. The property in question is ruled a non-marital legacy asset protected under federal lending guidelines." She turned to Marla. "Furthermore, the plaintiff's use of expired permission documents constitutes bad faith action. The handwritten note is ruled inadmissible due to clear prior revocation and documented misuse." Case closed. Marla walked out of the courthouse without looking at me. Her new lawyer was already on his phone, probably explaining to someone why they'd just lost an unloosable case. But the real fallout was just beginning. 2 weeks later, Janet called with an update. "Your wife's not having a good month," she said. Bryce had been quietly removed from his firm. No official announcement, just a missing name on the website and voicemail messages that went to a different attorney. Word travels fast in legal circles. When you bet a client's money on a case, you should have researched better partners' notice. Marla's consulting company was facing financial collapse. The voided loan had triggered other creditor concerns. Clients were asking questions about fiduciary responsibility and due diligence. How do you explain to business partners that you borrowed against property you couldn't legally use as collateral? The story found its way online through legal blogs that specialize in unusual cases. Nothing sensational, just a careful analysis of agricultural exemption law and lending oversight. The headline was simple: "Collateral isn't consent. The case of the legacy cabin." It went quietly viral in legal and real estate circles. Not celebrity gossip, just professional interest in a case where someone had missed something fundamental. The post didn't name Marla directly, but it didn't need to. The details were specific enough that anyone in Connecticut's business community could connect the dots. I read it sitting in my office on a quiet Tuesday afternoon. Professional language, careful analysis, no editorial commentary, just the facts presented clearly for people who understood the implications. One paragraph stood out. "The case illustrates how family legacy protections, properly documented and maintained, can supersede even well-intended temporary agreements. The lesson for lenders: agricultural exemptions aren't just suggestions, they're federal law. My phone buzzed with a text from Sarah. Saw the article. Clean coverage, no drama, just facts. Exactly what this kind of case deserves. I closed the browser and went back to reviewing vendor contracts, life returning to its normal rhythm. But something had changed in the way I approached the work. Every clause mattered now. Every detail had weight. You learn to read people when your job is spotting what they're not telling you. I'd just learned to apply that skill to my own life. The cabin was safe. The family legacy was protected. The law had worked exactly the way my grandfather designed it to work. Everything else was just paperwork. And paperwork I knew how to handle. I waited until the court proceedings were completely finalized. No appeals, no last-minute motions. The cabin was mine, untouchable. 3 weeks later, Marla called. I need to get some things, she said. Her voice was flat, businesslike. Personal items I left there. I drove up to Vermont on a Saturday morning in November. The lake was gray now, reflecting low clouds that promised snow. Winter was coming to claim the mountains. Her car was already in the driveway when I arrived. She was sitting on the porch steps, hands folded in her lap. No lawyer this time, no portfolio of documents, just Marla, alone with whatever she'd come to collect. I walked past her and unlocked the front door. She followed me inside without saying anything. The cabin felt different now, settled, like it had exhaled after holding its breath for months. The books are yours, I said, nodding toward a small stack by the door. And the coffee maker from the kitchen. She nodded but didn't move toward them. We stood there in the main room, surrounded by everything that had started this fight. My grandfather's furniture, his fishing gear, the quilt my grandmother had sewn by hand. For the first time in weeks, we looked at each other directly. You were right, Marla, I said. My voice was calm, unreadable. Everything in this cabin is marital property. Her eyebrows lifted slightly. Confusion, maybe hope. I stepped over to the fireplace and opened it, reached inside and pulled out the original permission note my father had signed. The one that no longer held any legal weight. The paper was yellowed now, fragile, his handwriting still clear after all these years. I walked to the fire and tossed it into the flames. Except the things marriage never touched. The paper curled and blackened, my father's words disappearing into smoke and ash. I walked to the safe behind the fireplace, the same safe where my grandfather had protected what mattered most, where the real documents, the ones that counted, were still secured. I closed the door, gently. The lock clicked into place with a sound like finality. You can have the chair, I said, indicating the kitchen chair she'd claimed during their first visit. I'll take the house. I turned back to face her. The memories? You never had those. Marla said nothing. Her face was still, but her posture was off balance, like she was standing on ground that had shifted beneath her feet. She picked up the books and coffee maker without ceremony. No final words, no attempts at explanation or apology. I held the door open as she carried her things to the car. She paused at the threshold, like she wanted to say something, but whatever words she'd prepared stayed locked inside. I walked outside after her, not rushing, not gloating, just walking. The wind was picking up, carrying the scent of snow from the mountains. Pine branches swayed overhead, making sounds like whispered conversations. Her car pulled out of the driveway for the last time, gravel crunching, engine fading into distance. I stood there until the silence returned completely. Then I went back inside and closed the door. And the cabin was mine again. Had always been mine, really. The law had just confirmed what my grandfather knew when he built these walls with his own hands. Some things you protect not because they're valuable, but because they're irreplaceable. I walked to the old boombox in the kitchen and ejected the cassette tape. My grandfather's voice, his final instructions, his insurance against people who forgot what family meant. The tape melted into silence. Outside, wind moved through pines that had been here longer than any of us. And somewhere behind me, the safe locked one last time.